1966 ခုနှစ် မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်228 HD AHUJA and 7 others plaintiff versus PC GHOSH deceased and 2 others defendants ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစောမင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Civil Regular Suit before Uttarpe Judge HD AHUJA and 7 others plaintiff versus PC GHOSH deceased and 2 others defendants Transfer of Property Act Section 53 a representative suit for declaration that a deed of gift is not binding upon the plaintiff whether a suit for mere declaration is maintainable whether court fees is payable under Section 7 4C of the Court Fees Act suit by creditors burden of proof of fraud on the creditors shifting of the burden to the debtor hell a suit under Section 53 Transfer of Property Act for mere declaration is not maintainable and that the court fees payable is governed by Section 7 4C of the Court Fees Act and that the plaintiff must pay court fees according to the amount of the consequential relief which they are now claiming. Velia Kona and another versus Ramaswamy Kona and another AIR 1939 Madras 894 AKACDV Chadia versus RMARS FEM and others ILR 12 Rangoon 666 Askar Ali versus CVRM FEN ILR 14 Rangoon 81 Maungba Maung versus Maungba Yin 1940 RLR 59 FB referred to her father in a suit filed by creditor under Section 53 Transfer of Property Act, the initial burden of proving that it is a fraud on the creditors rests on them, but if they can adduce facts which are sufficient to show prima facie that the intention of the debtor was to delay or defeat the creditors, the debtor must meet their case and explain his conduct. Mohammed Isha and others versus Mohammed Yusuf and another 1927 ILR 8 Lahore 544 referred to R. Basu for the plaintiff, Dima for the defendants, Uttarpe Judge. This is a representative suit for declaration under Section 53 Transfer of Property Act that a deed of gift executed by the defendant PC GHOSH in favor of the other defendants who are his wife and adopted daughter is not binding upon the plaintiff to the extent of debt 59,251.71 bias. It is the case of the plaintiff that they and the defendant PC GHOSH carried on the partnership business under the name and style of Mesa AHUJA Radio House at number 126 Sule Bagoda Road and AHUJA GHOSH and Company at number 254 264 Bar Street, Rangoon, that one of the terms of the partnership was that the partners should enjoy or bear the net profits or losses according to the respective amounts of capital subscribed by them, that the partnership was dissolved by mutual consent on the 1st June 1959 by a deed of dissolution by which the partners agreed to go into and accept the partnership accounts outstanding on the 31st May 1959, that on going through the accounts it was found that the defendant P.C. GHOSH had to pay Jet 29,491.83 piastres, being the amount which he had overdrawn and his share of contribution towards the losses incurred by the partnership business for the period ending 31st May 1959, that the defendant P.C. GHOSH was also liable to pay income and super tax amounting to Jet 19,157.19 piastres and also Jet 3,094.19 piastres as interest, thereby bringing the total amount payable to Jet 51,743.92 piastres, that on that August 1961, the defendant P.C. GHOSH collusively and with intent to defeat his creditors executed a deed of gift purporting to convey his sole property, namely a two-storied pucca building known as numbered 15 Soniram Park, Rangoon, with its site value at Jet 25,000 in favor of the other defendants who at the time of the transfer knew that the defendant P.C. GHOSH was indebted to the plaintiff and that the plaintiff were entitled to a declaration that the deed of gift was not binding upon the plaintiff to the extent of Jet 51,743.92 piastres during the progress of the suit, but before the hearing was started, the defendant P.C. GHOSH died and the other defendants were brought on the record as his legal representative as well. Then one of the plaintiffs, namely H.D. AHUJA, became an insolvent and the official assignee was accordingly substituted in his place as a plaintiff. The defendants contested the suit on various grounds, amongst which it was contended that the plaintiff sued for bare declaration without consequential relief was not maintainable and that the suit was not properly valued for the purpose of court fees. They further denied that the deed of gift was executed with intent to delay or defeat the creditors. On these pleadings, the following issues were joined. 1. Is the suit properly valued and paid for the purpose of court fees? 2. Whether the suit for bare declaration is maintainable without consequential relief. 3. Was the deed of gift dated the 3rd August 1961 made by the late P.C. GHOSH in favor of the second and third defendants with the intent to delay or defeat his creditors to the knowledge of the aforesaid alleged donnees? Without consideration, since the present suit is an offshoot of civil regular suit number 7 of 1962 of this code, the learned advocates for the parties agreed to adopt the evidence recorded therein as the evidence of this case and to base the decision of the instant case on that of the other one. Issue number 1 and 2 will be considered together. It has been submitted on behalf of the defendants that the court fees should have been paid ad valorem inasmuch as the suit is one for declaration with consequential relief and that a suit under Section 53, Transfer of Property Act, which entails avoidance of transfer by the debtor cannot be said to be one of declaration, pure and simple. The learned advocate for the plaintiff, on the other hand, contended that the suit under Section 53, Transfer of Property Act, is one for declaration without any consequential relief. In this connection, he relied upon the decision in Valia Guna and another versus Ramaswamy Guna and another one, where it was held that a suit brought by a creditor under Section 53, Transfer of Property Act, for a declaration that an alienation by the debtor is void against the creditors is not a suit for cancellation of a document securing money or other property falling under Section 7 4a, but a suit to obtain a declaration where no consequential relief is falling under Article 17a of Schedule 2 as amended in Madras. With due respect to the learned judge who had decided the case, the fact that the plaintiff in such a suit has asked for avoidance of the transfer to the extent of his and other creditors' claim clearly indicates that it is not a suit for declaration pure and simple, although the success of such a suit will not have the effect of cancelling the instrument of transfer executed by the debtor. It will necessarily result in the avoidance of transfer to the extent of the total claim of all the creditors, both present and future. In AKACDV Tedia versus RMARS, FEM and others too, it has been held that when a suit is brought under the provisions of Order 21, Rule 63 of the Civil Procedure Code by an attaching creditor to establish his right to attach and bring to seal certain property, and in order to succeed, it is necessary to avoid a transfer of the property on the ground that the transfer has been made with intent to defeat or delay the creditors of the transferor. The suit must be brought in the form of a representative suit for the benefit of all the creditors of the transferor. The valuation of the suit for the purpose of jurisdiction is the value of the property transfer, and not the amount of the attaching creditor's degree. If the creditors succeed in the suit, the degree endures for the benefit of all the creditors of the debtor, both present and future. The above decision had been approved by a bench in Asghar Ali vs. CVRM Fan 3. See also Maungpa Maung vs. Maungpa Yin 4, where it was held that a creditor cannot sue for a bare declaration that a transfer has been made by his debtor fraudulently with intent to defeat or delay his creditors. 1. A suit under Order 21, Rule 63, Civil Procedure Code, which is ordinarily governed by Article 17(1) of Schedule 2 of Code Fees Act, turns into a suit under Section 7(4)(c) of Code Fees Act. If a plea under Section 53, Transfer of Property Act, is made therein, there is the more reason to hold that a suit instituted under the provisions of Section 53, Transfer of Property Act, falls under Section 7(4)(c) of the Code Fees Act. I therefore hold that a suit under Section 53, Transfer of Property Act, for mere declaration is not maintainable and that the Code Fees payable is governed by Section 7(4)(c) of the Code Fees Act, and that the plaintiff must pay Code Fees according to the amount of the consequential relief which they are now claiming. Issue number 3. In a suit filed by creditors under Section 53, Transfer of Property Act, the initial burden of proving that it is a fraud on the creditors rests on them. But if they can adduce facts which are sufficient to show prima facie that the intention of the debtor was to delay or defeat the creditors, the debtor must meet their case and explain his conduct. In the present case, it is clear from the evidence of Mr. A.S. Hakim, recorded in Civil Regular Suit number 7 of 1962 of this code, that the defendant P.C. GHOSH was supplied with a copy of the balance sheet on the 2nd December 1959, and that he was therefore aware of the fact that he owed substantial sums of money to the plaintiff before the execution of the instrument of gift, date the 3rd August 1961. It is also not in dispute that the defendant P.C. GHOSH was not possessed of any property other than the building, which he had gifted to his wife and adopted daughter. It must therefore be assumed that the defendant P.C. GHOSH intended to defeat or delay creditors when he conveyed his sole and only property to his wife and adopted daughter. C. Muhammad Isha and others versus Muhammad Yusuf and another 5. In view of the decision in the Bank of Chettinad Limited versus Udo Sil, the plaintiff will be allowed to suitably amend their claim in the light of the answer to the issues numbered 1 and 2, and pay the deficit court fees within 1 month from this day, following which their suit will stand dismissed with cause. If the plaintiff amend their claim and pay the deficit court fees, there will be a decree declaring that a deed of gift, date the 3rd August 1961, is not binding upon the plaintiff to the extent of debt 46,173.31 piastres, being the amount decreed in Civil Regular Suit number 7 of 1962 of this code with cause.